set, everybody?
Yes, thank you.
Take your time. You ready?
I am, Your Honor. May it please the Court. I'm going to focus in on what Mr. Lentner did, and of course, if there's questions that the Court has, I'm sure they'll ask about how it relates to the overall schemes. Mr. Lentner, if he's been anything in this case, he's been consistent. And his defense has been consistently rejected. His defense throughout the Barr case was, this is merely a fee dispute. That's what this is all about. It's a fee dispute. His defense is, I'm not really a partner. And his defense is, I really didn't do anything wrong because Mr. Stewart was the expert and he led us down the primrose path. Rejected. Totally rejected. Mr. Lentner has claimed that to the referee, I don't know how many times it was claimed, about being a fee dispute, and finally towards the very end, even the referee with an enormous amount of patience said, this is not a fee dispute. And he had that tone when everyone knew what he meant. And of course the referee was correct. Like all the other respondents, this is where they're all connected, the referee found that Mr. Lentner acted out of greed. He betrayed his own clients. He betrayed the bad faith lawyers. He deceived many, failed to properly advise his clients, was dishonest, committed multiple offenses, made false statements during the disciplinary process, refused and continues to refuse to acknowledge the wrongful nature of his conduct, and showed indifference to making restitution.
Was a partner with Laura Watson?
Well, the name of the firm was Laura Watson, PA, doing business as Watson Lentner.
This is Laura Watson's
husband,
law partner or
former husband, law partner.
Oh. Okay, so former partners in many ways.
Yes, ma'am.
So what's going on with Laura Watson?
My understanding is she defaulted in the Barr case, and either you have or you'll soon have the ORR in that case. I didn't handle that case. I stayed in touch with the prosecutor who did, but my understanding is you'll soon have that case. Mr. Lentner, like his co-respondents here today, went to trial. Of those people, in this case, he's the most involved. Of the three respondents here, he's the most involved. He represented the lead plaintiffs in the bad faith case, the Gold Coast case. That's Mr. Lentner. He accepted responsibility for all the clients listed as plaintiffs in the Gold Coast case, and all those to be added. He was to share in the fees and did share in the fees in the Gold Coast case, just like in the same amount as the other 5 PIP lawyers.
So did their firm get a $4 million fee also?
No, they got less. Their fee was determined to be less. I believe their total fee was $2.5 million. They had fewer clients, we didn't have anything to do with that. The way it was done, they had fewer clients, so they wound up with less money.
But they had some bad faith clients.
They had bad faith and had.
What did their bad faith clients get out of these settlements?
Well, the total is $1.75 million, and that relates to it's a very good question. It was about something I was about to go into. Is 2 of their clients, the lead clients, had entered into a side deal, and you may have read about that, a side deal with the 2 lead Gold Coast bad faith plaintiffs, and they wound up getting, not coincidentally, more money than everybody else. And the courts found that was a side deal. That was found by Judge Crow, and it was ratified by the referee. But
the other ones, what did they get out of this whole thing? The bad faith clients that you say Mr. Lentner was representing.
I don't know exactly. I think he had 15 or 16 of those clients in there, and there was some structure as to how those clients were paid. The fee agreement was 60% to the plaintiffs and 40% to the lawyers, which is increased in terms of what the bad faith lawyers were going to get, but it was always 60-40. So out of $1.75 million, 60% is about $1 million, a little less than $1 million, divided up by 36 individuals. I don't know how the exact division was.
Did the Watsons make restitution to anyone?
Neither Mr. Lentner nor Ms. Watson
was the judgment satisfied? I mean,
no. The judgment was because the plaintiffs, the bad faith lawyers in the Crow litigation, were unable to get all the bank records. The judge could not connect the money paid to Laura Watson, PA, doing business as Watson and Lentner to the individuals, couldn't pierce the corporate veil. So the judgment is against Laura Watson, PA, doing business as Watson and Lentner, not personal. So collection has been very, very difficult for the victims, but the referee has ordered that Mr. Lentner recommended disgorge what would be, and this is a little complicated, stay with me on this, because I had to think this through as to what the referee was doing. He ordered the money disgorged and paid to the client security fund. And the amount of money is about $800 some odd thousand, which is 1/2 of what they were paid, the $2.5 million, with interest divided by 2. Because it was, the referee thought it should be 50-50.
So the money is to be paid to the security fund and not to satisfy the judgment?
Correct.
Isn't there a problem with that in terms of it's not an excessive fee claim, and is anybody claim under the?
I think this court has the power to do that. I'm not going to tell you what's right. We sought restitution of we sought disgorgement of the full fee, 50% of the full fee. We sought that of that. The money that's owed to the bad faith plaintiffs should have been paid, which was the judgment, and then from there, the remainder, which there was a remainder, should have gone to the client security fund. That was our request. Same as the request we made in the 2 Kane matters. And the referee basically decided that based on the money coming from the Kanes to the bad faith lawyers in the bankruptcy, which was on its way, he felt that with that money and with the Marks and Fleischer money, they hadn't paid enough. This money's not going to them, it's going to the client security fund. And that was the court's order, court's recommendation.
Is there a difference? I understand partnerships and PAs and all those kinds of things, but in connection with the actual day-to-day activities and work on these cases, not these kinds, but these cases, did both Watson and this respondent conduct the cases on the same level of involvement?
My understanding of the evidence is there were different roles. And
it seems that's the way this is being presented, is that the role of this respondent may have been not a little, but substantially less involvement.
No, different, not less.
Just different. Okay, would you explain that so we could understand that?
Yes, sir. Mr. Lentner's responsibility in this firm, he was the client contact. He was the one that had contact with the clients. He was the one who, of the 6 respondents, he was the only one who appeared at the mediation. His 2 clients were the lead clients. He took full responsibility for all the bad faith clients, like everybody else did with an agreement.
Is this the mediation with that Larry Stewart did?
Yes, ma'am.
And was he at the ultimate negotiations where they ended up with whatever the settlement they came to? The
secret meeting in May?
Yes.
He was at that meeting. He claims I think he said he claimed he was reading a Sports Illustrated. He claimed he was reading a Sports Illustrated while he was there.
Had he been working the files before Larry Stewart got involved?
He was
as a lawyer, not as a rainmaker or something like that.
My understanding is he did hours on all the cases. He was the one who had the direct contact with the clients, is what he claimed.
Well, again, you're saying 2 different things. Come on now, you're talking past me on that. There's a contact with client rainmaker, and then there's the contact with client. I'm the lawyer that's working on this case. Please answer that one. That's what I'm looking for. Who's working on this case, or were they both working on it to the same extent? That's what I'm trying to understand.
I understand, Judge. When the case was settled, Mr. Lentner was the one who signed the letter, the disagreement between counsel. He signed that letter that went to the bad faith clients. He then was the one, and he testified, he was the one whose job it was to contact every single client, and he said he did, to contact them. And he said he did it by paper and by telephone. And to get them to release their claims in its entirety so that he and his wife could collect $2.5 million.
Well, that's not what he told them. He told them they were going to be collecting. Okay, so when he contacted each of these clients, did he disclose what the agreement with Progressive had been?
No.
And when we say about, because Watson, they were a partnership, but at the time of this case, they were husband and wife?
Yes, ma'am.
But it was, so even though it was a Watson PA doing business as, again, it was both of them, did they both share equally then in the fee?
We were able to trace, with the help of Bill Herron, one of the bad faith lawyers that was my key witness in trial. We traced it through the bank records, and the judge found it was about $1.25 million over the year after that settlement, and that's why he ordered the amount of money he ordered. Yes, they split it, looked to be evenly. When one got a check, the other one got a similar size check. Both got a check that was made out to their common child.
But it sounds to me like as between, and again, Watson and this respondent, that this respondent was more involved than Watson.
In some ways. In some ways. And these are the ways that I'm talking about now. They were more involved in the actual mediation. He was online with Mr. Stewart and Mr. Herron way more. Matter of fact, you probably remember Ms. Watson's email back to the bad faith lawyers after the mediation, and I quote, "We need to keep our foot on their throat and not let them loose." You may remember that quote. That quote followed an email from Mr. Lentner. I'd like to read that email to you. And I think it was Justice Quince made reference to this. This was Mr. Lentner's email. Well, first, let me go through. This is Florida Exhibit 34 that's in the record. It began with an email from Mr. Stewart. "We had a hearing set before, but the special magistrate wanted us to first clear up his authority. Regarding distribution, while this is very premature right now, disposition can be made in any formula that everyone agrees on. Amir called me about this already. The key is that everything is totally transparent, and all healthcare providers are informed and sign off on it." This is the email that answered Mr. Lentner's and Ms. Watson's. Before that.
That's from Stewart.
That's from Stewart, and that was sent to Ms. Watson and Mr. Lentner. Before that, Laura Watson, "Larry, did we get a new hearing date for the motion to compel sanctions? We need to keep our foot on their throat and not let them loose. Let me know when the new date is set." Laura. Before that one, this is from Mr. Lentner, who attended the mediation. "Larry and Bill, I thought both of you did an excellent job at the mediation. I can't think of one thing we should have done differently. On a different note, earlier today I received a call from Eric and Jerry, the two lead plaintiffs. I must say I was expecting it based on their questions at the mediation. Essentially, they are concerned that their interest in any bad faith settlement is getting diluted by the number of potential claims. I share their concern, and that has always been my perception that the named plaintiffs should be entitled to a greater share of any recovery than another provider who, number one, does not have a written agreement, number two, is not at risk from any OJ, and number three, has otherwise not contributed or participated in any of the discovery."
Is that the did they have bad faith clients?
Yes.
So
but he's referring, Justice Parenti, he's referring not to the bad faith clients, because he's saying the ones that are not in the litigation. He's referring to the PIP clients here. He's conceding that the PIP clients should share in the money, and that's what was discussed in mediation at which he attended.
Well, now, what we say in our opinion disbarring Laura Watson, that Watson never told her PIP clients that Progressive paid funds to settle the bad faith claims, and they weren't allowed to participate in this recovery despite the fact they were required to release their claims. Is that same as to this respondent? And maybe, as you're sort of saying, maybe even more so.
Our position, it's worse. Because he's the one who actually went to each of the clients and did not tell them anything about the important facts, which is we're sitting with $2.5 million as an offer, and we're about to shut you out as long as you waive or give up that claim, which they did. Never told him about this mediation. His claim at trial was it was protected. He couldn't tell him. There's ways of telling clients what's going on without violating any other privileges. It could have been done. It was rejected. His testimony has been rejected. It's rejected by Judge Crow and rejected by the referee. The referee found that he testified falsely in the proceedings. And I'll save, obviously, the rest for rebuttal. Thank you.
All gone.
All gone.
Good morning. May it please the court. Jack Seiler, and I represent Darin Lentner. First, let me correct a couple comments that were made, just so we're very clear what the record says. And I would hope that this court has looked at the record from the referee, because, in fact, the referee repeatedly instructed Mr. Rothman to quit referring to Mr. Lentner as a partner because he is not a partner. Judge Crow found he was not a partner in the law firm. Judge Shayhood found he was not a partner in the law firm.
But here's the thing about being partners, and is that there are partners in terms of partnership agreements being filed or a PA, but weren't they, this is a husband and wife, they were Laura Watson, DBA, Watson and Lentner. So what is it that's so awful about referring to him as a partner with Watson? Was did she direct him? Was he a younger lawyer that had little experience? I'm trying to...
Let me answer. Yes, yes, and yes. He did not. They were married. She is a longer-serving lawyer.
By how long? How much?
A couple years longer. And she was also a sort of the lead counsel on all these cases. But specifically, they got married. They had a child together. In 2004, they were separated. 2005, they filed for divorce. So while this is all going on and they're saying they're partners, one, they're not partners. Laura Watson owned 100% of the law firm. The evidence is undisputed in every record. Laura Watson owned 100% of the law firm.
But he's ready to throw Laura Watson under the bus here.
He's not throwing Laura under the bus because, secondly, Your Honor, Laura Watson also controlled the trust account. Mr. Lentner had no signing authority on the trust account. It's why the trust account charges in this case were all dropped.
So I'm trying to understand this. What Mr. Rothman finished saying was that this respondent was responsible for going to all of the clients and obtaining releases of a bad faith and PIP claim. Is that true or not true?
My client was responsible for communicating with the clients. The way it was structured, and that's, again, to address what Justice Lewis brought up, my client had almost no time in these files. My client was the client contact. He had the relationships with the healthcare providers, and he would bring them in. Was he at the mediation with Larry Stewart? He was at the mediation, which I'll get to.
$3.5 million.
No, but that's not accurate, and that's what also I'll get to. But let me address this with the clients. They had about 700 cases with about 85 clients. Mr. Lentner was the client contact to make sure these doctors knew what was going on with their cases. Of the 85 clients, only about 18 or 19 were in the bad faith claims. The other 60-some had unperfected and unfiled bad faith claims. They were not in that group. Larry Stewart didn't want them in the group. Larry Stewart wasn't going to include them in the group because they were, just as you heard from the Canes, they were unperfected or unfiled. They weren't good bad faith claims. The best bad faith claims were Drs. Fishman and Stashak, who were the lead plaintiff, who, by the way, testified at our trial in support of Darin. Dr. Stashak, if you go to the record, testified in support of Darin Lentner. This is the client that supposedly is the victim. And he defended Mr. Lentner at trial. We read into the transcript. Think about this. This has now been...
Is this the same? Is he one of the two that had the other agreement and got a substantial sum for their bad faith claim?
All the bad faith clients got about $1,400 for their claims, in addition to their...
asking for the side deal.
The side deal.
That's the other thing about the side deal, Judge, and that's why I really encourage you to go to the record, because if you look at what they alleged to be a side deal, the side deal was the original meeting when these clients were brought to meet with Mr. Stewart, and Fishman and Stashak had been burned in a prior class action lawsuit, not group action. This is group, not class. They had been burned because it got so diluted. So they said, we never want to lose control of this case. And that alleged side deal was them telling Larry Stewart, in Mr. Lentner's presence, that they did not want to lose control of this case. They were not going to end up in a class action where it was being driven by others. That was a so-called side deal. So, I think you have to look at...
But what is the answer to the question of is that one of the clients who got a substantial amount for his bad faith claim?
They got $1,400 per claim. That's what they got. But they just have the largest group of claims. Fisherman and Stashak was an office in Palm Beach that had a very busy practice. So they got about
They got 14, so...
They all did. Everybody in the bad faith action, Your Honor, got about $1,400 a claim. That was for the bad faith, but that's because they had perfected and filed bad faith claims. The cases that the Keynes talked about to you earlier, they're right. They weren't perfected, they weren't filed. The other 700 cases we had weren't perfected and weren't filed.
I'm trying to think of what universe you and I are in that both is similar and different, because here is the issue. It may be that certain of their clients, quote, deserve more money than other of their clients. But how many clients did they have to get releases from?
Judge, they had about 85 clients, of which about just shy of 20 were in the bad faith with perfected and filed claims.
I think that the problem, again, if they had gotten $2.5 million, that was for everything, including their fees and something to go to the clients?
No, their clients got paid every single cent of their damages. That was about, it was a couple $100,000 on top. Their clients were, Judge, and let me add one more thing that was added in. Okay, I'm sorry.
Do they have an obligation, because I don't know how these PIP cases go, that when they're distributing the money that they get to their client, to show how much in attorney's fees and costs they have? I mean, that's what I used to remember that we had to do for every client. Was that done in this case?
In the Gold Coast case, it was. But in fact, they took no fee in the Gold Coast case. In the non-Gold Coast case, well, they didn't take a fee, Judge. That, the comment was made.
Did they not get $2.5 million?
But they took no fee in the Gold Coast out of the 175.
Yeah, that's
$2.5 million was for about $4 million in time spent hourly on their PIP cases.
And they don't have to show anybody, any client, that what they got in fees and what they're paying to...
Judge, the agreement they have with their clients, and remember, there's two separate agreements here, and I think this is why I'm so delighted we're going in this area finally. There are two separate agreements with the clients. When the clients come in, they hire the Watson law firm, of which he was not a partner. He was an associate without signing authority. They hired the firm to collect their benefits, their interest. In the agreement they reach with them is they say, after our benefits and interests are paid, you can pursue your fees and costs, like the Palma decision, and you can keep your fees and costs from that recovery. In this case, in addition to the releases, no one's talked about this yet, in addition to the fact that every client they have, every client, and it's not surprising, it's now 12 years and not a single client's ever come forward complaining. The only clients that came forward in their defense. So it's not surprising now in 12 years, 4,000 days, nobody's come forward and said I'm a victim here.
So you would say the same from Watson, that we removed her from the bench on an inappropriate premise?
No, Judge, there are several issues here that I'll get to, and that's what I was hoping we'd have a chance. So as it relates to this issue, this is not a basis to remove at all, because every one of our clients that were in the bad faith case signed an affidavit and a release. Those are all in the record. Please read them. In addition, the clients that were not in the bad faith case got paid their fees, their costs, their interest, their principal, and got two more things that Mr. Lentner negotiated that he asked for. One, they got released from any clawback lawsuit, because at this time, Progressive was going after the doctors to claw back what they thought were overpayments. We got a complete release of that. And secondly, they got released from having to go to any more depositions. If you know how a doctor's practice is, they don't want to go to a deposition for a $400 bill. And Progressive realized they could put pressure on them by starting to set them all down for depots and making these guys go and sit for a $400 deposition. And as part of this, they said, all right, we're done. We'll get you paid 100% principal, interest. Your fees and costs are covered. You have a relief from clawback. And by the way, you've now been released from discovery and deposition obligations. In addition, there were proposals for settlement out there in the bad faith case, which hasn't been discussed, that it was showing that after the Campbell decision came down by the U.S. Supreme Court, and after the Florida State Legislature, while I was there at the time, passed a cap of $2 million, that all of a sudden, you ask why 175? Because of the $2 million cap that was passed across the street. They couldn't recover more than that for the bad faith case, number one. Two, you can't have bad faith class action. It's not allowed. So this was a group action proceeding. Now, going back just real quick, I know I'm running out of time, but Mr. Lentner's involvement, Mr. Lentner was the client relation. It's been clear he did not have any signing authority, didn't write any checks to distribute any funds. In addition, though, Mr. Lentner, at the first settlement, the MOU, went, as they said, he made a joke of it, he was reading Sports Illustrated, but they basically said, you haven't been working on these cases, you don't know what's happening in these cases, this is undisputed. Go sit in the lobby and read a Sports Illustrated. So that's what he did, because he had the client contact, but he hadn't been working these cases, as Justice Lewis pointed out. Secondly, he left. His son with Judge Watson was at home alone. He left to take care of the son. Look at the documents. The MOU, the Memorandum of Understanding that the bar made a huge issue out of, is not signed by Mr. Lentner. The amended Memorandum of Understanding that tried to remedy that is not signed by Mr. Lentner. If you go look at the documents, you'll see his role was the client contact. He didn't negotiate.
Is that the information that was given to the clients that he was? I thought they represented in the material sent to the client that he was, in fact, a partner.
No, the issue with the partner was it was printed up by others. At trial, this was addressed by Judge Haywood. He didn't prepare that document. The firm's name was Watson, Laura M. Watson, PA, DBA Watson and Lentner. They were married at the time, and for whatever reason, Laura Watson put her name first, his name second. Undisputed, he has no shares in the firm. But secondly, as it relates to what he did with the clients, he did have client contact, and he was the one that met individually. And again, I ask you to go to the record. Look at what Judge Haywood looked at, and Judge Haywood worked really very hard on this and did a remarkable job. But look at what he looked at. There was not a single testimony, a single piece of evidence rebutting his testimony that he met with his clients and explained to them what was going on here. And because of the two classes of settlements, the Gold Coast bad faith litigation and the other side, which was strictly the doctor's bills unpaid, he could not tell the people in the doctor's bills unpaid who were not yet in the Gold Coast litigation. And by the way, everybody in the Gold Coast litigation, this hasn't come up today, all had signed attorney-client agreements, every one of them with the Stewart firm. So you've got these signed agreements for 37 plaintiffs in that case. You've got his 85 clients that are not in that case, or 60-some that are not in the case, don't have signed agreements with Mr. Stewart on the bad faith.
How many did he have? He had the two lead plaintiffs.
He had he had about half.
So he did have half.
He had about half.
Okay.
And by the way, he never took a fee on it.
Right.
So when this issue came up, Judge, about, did he not make it whole, they never took a fee on the 175. They finally just said, look, Larry was upset. They said, here's $700,000, of which a portion was their law firms, not his, their law firms. They put it into the court. It went into escrow. Mr. Stewart got it. So it's not fair to say they never got his money. He never made a fee on the bad faith. On the non-bad faith, they had about $4 million in time, and they collected about $2.5 million in revenue. They lost over $1 million in this settlement to get it done. And when you look at Mr. Lentner's role, again, if you look at the fact that they separated in 04, they were filed for divorce in 05, this whole thing's going through. We tried the case in front of Judge Crow. I hate to say this, I'm the only guy here that tried all three cases in this. I tried the case in front of Judge Crow. I left there. He got sued for 5 different counts. Left there with a defense verdict and a reservation by the court on my attorney's fees against the plaintiffs. He wins the Crow case. Wins it outright. If you read it, they got sued for 4 torts and a contract action. He won all 4 torts. The contract action his firm lost, which the judge found he wasn't the owner of. And we leave there with a defense verdict as prevailing party in the Crow.
But that's because of the legal structure. It's the same way that the Canes was Cain and Cain, and not because of...
I would disagree with that being the reason, Judge. If you read the Crow decision, Judge Crow, again, an outstanding jurist, but Judge Crow did not differentiate between the 6 lawyers. He called them the whole time either the PIP lawyers or the bad faith lawyers.
But I'm saying the reason there wasn't an individual judgment, and again, not to take away from your advocacy, was because the firm was not owned by him. So there was not a basis to award the individual damages, I thought.
No, because Judge Watson owned the firm, and then she did not have individual damages award against her either. Both Judge Watson and Mr. Lentner.
So the firm of Watson, PA, did not have a judgment against her?
Only Watson, PA. Laura Watson was sued individually, though, and she was not found to be liable either. They could not pierce that corporate veil because they found no wrongdoing. Remember, there was no underlying tort found by Judge Crow.
Yeah, I sure
Only an
reading
underlying.
Judge Crow's order, I sure didn't read it as he thought there was no wrongdoing, but I'll go back and look at it to see if we're having different.
We actually did this on cross with Todd Stewart at trial, where we went through Judge Crow's order like this, and I would encourage you to look at that record because the finding was an unjust enrichment. That was the sole finding by Judge Crow. There was no tort finding. Secondly, when we went to Judge Shayhood, as you know, he imposed the lightest sentence on Mr. Lentner. He heard this for several weeks. He listened. He's made comments in the record as to his limited involvement. It's why he imposed 2 years suspension and did not impose disbarment. He had a much lesser role throughout, and the record's replete with that. The third thing, the only thing I would encourage you to look at, and I got 5 seconds left, is simply the issue of the finances. Ordering him to pay a victim's compensation fund, $800,000, is just flat out not supported by the law and not supported by our rules. There is no client that has ever been victimized. There's no client that's ever come forward in 12 years. There's no client that's out any money, and even Judge Shayhood realized that at the end of the trial. He wasn't going to give the money to Larry Stewart. He's already been paid way too much for his time. So instead he says, I'm simply going to take the money and put it in the client's victim compensation fund. The problem is it's not supported by the law in Florida. There was no illegal fee, no excessive fee, no unpermitted fee found by the judge. So you can't just simply disgorge his fee for that purpose. So I would just ask that if you look at what's happened, we've asked for a 60-day suspension on behalf of Mr. Lentner. We agree he did 3 things wrong. The original MOU was an error, but he didn't sign it, nor did he draft it, but he acknowledges that he helped implement it after it was signed and drafted. That was wrong on his part. The second thing he did wrong was not having those signed statements on the non-bad faith cases when they got their money. And then also in terms of he had no responsibility for the trust account. So we would ask that the 60 days be the penalty and that the requirement to reimburse the victim's compensation fund not be upheld because there's been no victim here.
Didn't he sign the letter to the client?
He signed the second letter to the client that tried to correct the error. The one thing that hasn't come...
He signed the letter to the client that all the other folks signed, which contained misrepresentation.
Well, the letter, Judge, was drafted by the other attorneys, and that's... He did sign it. I fully acknowledge.
Right, that's it.
But I will just leave it with this, that the letter that was signed was a letter that was given on the advice of ethics counsel, Erwin Gilbert, who told them at that time they needed to send out such a letter.
You're out of time. Thank you, sir. Mr. Rothman, I'll give you 2 minutes. You're out of time, but I'll give you 2 minutes. Thank you, Judge.
Before you start 2 minutes, I just want to, I had said, I thought erroneously, that Fran Anania was no longer with us. I don't think that's the case, so I apologize if I implied that.
He's still alive, Your Honor.
I thought you meant no longer with us, no longer a lawyer. I was taking it in a much smaller sense, Judge. I would have corrected you. And I will be very brief. Mr. Lentner has been consistent. He's consistent before this court today. He's flat out wrong. The referee found that except for greed, and I'm quoting, except for greed, there was nothing including the MOU and AMOU that prevented the PIP firms from allocating additional money from the settlement to the non-Gold Coast case clients of each of the 3 law firms. Rebuttal, the PIP lawyers, including Mr. Lentner, were the ones who decided how much money they would take as attorney's fees from the aggregate settlement received from Progressive. Therein lies the ultimate conflict. The settlement pitted the lawyers' interests against the interests of their own clients.
I thought Mr. Seiler stood there and told us that the PIP clients received all that they were owed plus interest. Were they or were they not?
They were not. They were owed part of the bad faith judgment. They waived it. That had value. They didn't make that choice.
Bad faith. Were they paid the PIP?
The PIP, yes.
You guys make this distinction. Yes. All of the PIP clients were paid. So the question is the bad faith clients. Did they have contracts for those? Were there any of them?
No, sir. Then your decision in Adorno is wrong, Your Honor.
In what?
Then your decision in Adorno is wrong. Because Mr. Adorno had no contracts with his other clients. And you suspended him for 3 years for not having a duty.
Where it says other PIP clients, bad faith claims or potential bad faith claims are part of the negotiation for the bad faith settlement.
Absolutely. That's what the referee found. The referee further found that the most egregious violation by Mr. Lentner was when he abandoned the bad faith claims of his non-Gold Coast clients, who received absolutely nothing for those claims in order to obtain substantial attorney's fees for himself and Laura Watson.
Because under those, he would be able to not disclose how much of an attorney's fee he got.
No. The judge found that they did not provide a closing statement. Their defense was...
He said they didn't need to.
I'm sorry?
He said today that they didn't need to because they got any fee that was...
Judge found they did. The judge found there was a contingency fee agreement, they had to, but he called it a technical violation. In this case, it's our position. It's not technical, because then with a closing statement, they would have seen $14.5 million, or at least, and by the way, it's $3 million was the total amount. They kept 2.5 of the $3 million. So you asked that question, I want to answer it. It said, Mr. Lentner, he sacrificed the rights of all of his PIP clients for settlement on behalf of Gold Coast claimants. He, Mr. Lentner, sacrificed the right of all of the clients, both PIP and Gold Coast plaintiffs, when the majority of the settlement money went into his and Laura Watson's pockets as PIP fees, rather than to pay the clients the value of their bad faith claims. There is clear and convincing evidence Darin Lentner knowingly and intentionally participated in and accepted the benefits of the aggregate settlement, and they knowingly and intentionally failed to inform the clients of the conflicts and obtain waivers for those conflicts. As to the non-Gold Coast clients, he utterly failed to advise those clients of the true nature in which the secret settlement had occurred, and by failing to disclose all of these material facts, Darin Lentner deliberately misled the clients, so the clients would sign off on the settlement and Progressive would release the settlement funds. The clients never were given the opportunity to make informed decisions about their cases. This is a very good referee, after 13 days of hearings, made that finding. Under the standards, under the aggravating factors, the 9 significant aggravating factors in this case, Mr. Lentner deserves to be disbarred. Thank you.
Thank you for your argument. We're in recess.
Thank you, Your Honor.
All rise.